Welcome to this SRA webinar on trust and company service providers. I'm Zoe Allen Robinson. I manage the anti-money laundering proactive team and I'll be chairing the session today. And I'm joined by my colleague Mark Boyle, anti-money laundering policy manager at the SRA. Mark's going to speak for around 20 minutes on this area. The webinar is a companion to the trust and company service provider guidance that we put out last year on our website. So a lot of the content will cover that guidance. Mark's also going to mention some other essential reading and available resources in this area. We've also allowed some time at the end to do some questions. So I would encourage you to submit live questions using the link below this screen. So this is the first in a further series of webinars that we're doing that are free on anti-money laundering. So would encourage you to check out our events page for further events. The next webinar that we have scheduled is on reporting AML concerns, where one of our colleagues will be joined by the National Crime Agency at lunchtime on the 7th of October. We also have one coming on firm-wide risk assessments and our thematic project on the role of money laundering compliance officer and reporting officer later in the year. So Mark Boyle has been in his current post for 2 years and has a policy background, having previously worked at RICS, and he also wrote the TCSP guidance, so is the expert in this area. So I'll hand over to you, Mark, for your presentation.
Thank you, Zoe, and thanks to all in attendance. So moving on to the first slide, I'm going to take a slightly technical start and talk about the legislation itself, because I think it's really important to understand how trust or company service providers, as they're termed in the legislation, what the definition is and kind of understanding what the boundaries of that are. And we're going to talk about that quite a lot actually during the session. So the definition, TCSP is defined in the regulations as a firm or sole practitioner who, by way of business, provides any of the following services. So I'm actually going to go through the definition itself just for clarity's sake. So forming companies or other legal persons, acting or arranging for another person to act as a director or secretary of a company, as a partner of a partnership, or in a similar capacity in relation to other legal persons, providing a registered office or business address or correspondence or administrative address or other related services for a company, partnership, or any other legal person or legal arrangement. So just to highlight as we're going through, these are very, very broad, very inclusive. And the last one is acting or arranging for another person to act as a trustee of an express trust or similar arrangement, or a nominee shareholder for a person. And there's an exemption there for companies who are publicly traded. So it's pretty comprehensive. I think you'd agree. If kind of it's pretty much everything that might involve working to create or adjust or amend a trust or company. And one other thing I'm going to bring in here is to kind of talk about another element of the regulations. So all of that definition is in Regulation 12.2. That's what sets out what a trust or company service provider is. And if you do anything that's there, you're in scope as a TCSP. In Regulation 12.1, it talks about independent legal professionals. Now, we supervise about 6,500, give or take, firms for anti-money laundering. And the vast majority of those regard themselves as an independent legal professional. And as you might expect, we're a legal sector regulator, so that makes a world of sense. But we have found recently that there's a bit of an issue with the regulations that I'm just going to highlight here. So 12.1, as I say, talks about independent legal professionals, and it's all the stuff that you would expect, a lot of kind of transactional work, buying and selling, etc. But you go down to 12.1e, it states the creation, operation, or management of trusts, companies, foundations, or similar structures. Now, that sounds an awful lot like what I just mentioned in the definition of Regulation 12.2. And it highlights this issue whereby if you are in scope of 12.1 by virtue of 12.1e, what I just mentioned there about creation, operation, management of trusts, etc., then you are very likely, if not automatically, in scope via 12.2 as well. I would regard this as a suboptimal structuring of the regulations, because I think that it would be easier if they were there was a cleaner separation between the two. Unfortunately, there is not. And one of the issues we've encountered recently is firms who have correctly declared themselves in scope of 12.1. They've said, yes, I am an independent legal professional, and do some, if not all, of those services included, but didn't recognize that by being in scope by virtue of 12.1e, that actually automatically pulls them into 12.2 as well. And that seems like a very, kind of technical issue. Unfortunately, I'm going to go on to explain to you why it's not, and actually why it's quite a serious issue. But just a flag that if you're in scope of Regulation 12.1e, well, then you're very, very likely in scope of Regulation 12.2 as well, and are probably a trusted company service provider and need to regard yourself as such. So moving on to the next slide, what does that mean for you? So the first element of this is that it totally changes how the SRA goes about approving your firm. So for independent legal professionals, as I say, the vast majority of firms, you need to have your beneficial owners, officers, and managers checked under Regulation 26. Now, Regulation 26 is a very narrow test. All that needs to happen is that we need to establish that those beneficial owners, officers, and managers, the acronym we use is BOOMs, that your BOOMs are not subject to any of the disqualifying convictions in Schedule 3. We largely do that by ensuring we do a disclosure and barring service check, a DBS check, a criminality check, effectively, to ensure you don't have any of those disqualifying convictions. And if we can establish that, we can establish that you haven't been disqualified, then we have to approve you. It's a very, very narrow test. All we're doing is seeking to establish whether you meet the criteria, and that's the test for independent legal professionals. And then we approve you. You're supervised, and you're away to go and provide your services. It's very, very different for trust and company service providers. So you apply to us in the same way via an FA10 or FA10B form, but then the test for your beneficial owners, officers, and managers is much broader. It's a fit and proper test, and we can have regard to, frankly, any information that we have on hand to judge whether you're appropriate to be approved. So that might include intelligence we could have received from law enforcement. It could include your regulatory history with us, and essentially, it's a much more holistic approach we can take to whether your beneficial owners, officers, and managers are appropriate for approval. That's issue one. Issue two is that technically we don't approve TCSPs or their beneficial owners, officers, and managers. Technically, we can't. The legislation sets this out. We are only able to recommend approval to HMRC, who have the power to approve or not approve. And HMRC also have a big I always imagine it's a huge vellum scroll which they're writing with a feather quill, a huge list of all the TCSPs in the UK, and effectively, if you're not on that list, you cannot legally function as a TCSP. I would say slightly unhelpfully, this TCSP register is not publicly available, so it's not something you can kind of go and check to make sure that yes, I'm on the list. The process is you tell us that you're a TCSP, we apply this fit and proper test, then we make a determination as to whether we're going to recommend you for approval to HMRC, and then there's an administrative step where we transfer the information over, and all of that means then there's a bit of a delay in the point of us making our kind of decision about whether to recommend, and the point at which you're on the register and then can actually provide TCSP services. So when we provide decision letters like that, we generally say something along the lines of, please wait until Monday of next week, so to allow the administrative process to cycle. I am not going to sit here and tell you that if this was my choice to design this system, that this is how I would design it. I think, unfortunately, a lot of this is kind of set by the rigidity in the regulations. And I guess a wider note of context is that there's a call for evidence about about the AML regulations right now, closing on October the 14th. If you feel this is an issue for your firm, this is probably a good time to make that known to HMT via the call for evidence process. But it's just a flag that the regulations are not perfect, and I think I've already kind of highlighted some of the examples here where they're not perfect, but they're also law. So it's really important to make sure that the kind of the technical compliance is achieved as well as the spirit. So I've already mentioned the way you tell us is through an FA10 or FA10B. Those are available on my SRA. And yeah, ultimately, HMRC is the one who approves, and also they hold the list. The idea is that they're holding this list so that law enforcement can confer with them if they have a question about the probity of any TCSP. But it would be a positive development potentially in the next few years if they were to start publishing that. There have been some sounds around that, but unconfirmed at this stage. Okay, moving on. TCSPs in the legal sector. I think I've kind of dealt with a lot of the more technical stuff at the top of this session. I'm kind of moving on to a little bit more kind of narrative and description here. I'm going to talk about some of the issues of risk as well. So just to kind of talk about how TCSPs in the legal sector are in some ways different to other TCSPs. One of them is that scale of work done as a TCSP. So to actually understand how kind of TCSPs are discussed, it's good to understand what the other TCSPs are doing. So the reason HMRC is appointed as the approver of TCSPs more broadly is because nominally they're the supervisor for TCSPs that are not a member of a professional body supervisor. So if you were to start a trust company agency company that wasn't regulated by the SRA, it would be HMRC's responsibility. And I think broadly speaking, those kinds of companies deal in high volume. And I think that there's an awful lot of concern about the risk that creates, about the level of due diligence they're doing on their clients, and the ease with which they can be utilized for adding opacity to the path of money and assets. So I think that's kind of one of the key concerns, pardon me, and one of the key differences, I think, between the TCSPs in the legal sector and TCSPs that are outside of the legal sector in that way. I think the other kind of key one, and this is maybe a double-edged sword, is that broadly speaking, the firms that we supervise and regulate don't exist, solely as a trust or company formation agent or related. Often the kind of the trust or company work they do is ancillary to some other matter. That matter could be in scope of the regulations. It might be related to a conveyancing matter, something like that, or it could be ancillary to a piece of work that's, for example, out of scope. Potentially some piece of family law or employment law or something like that. There might be a call for creating a trust or something like that. It might be a requirement of the client. The important thing to flag there, though, is that just because it's ancillary to another matter doesn't mean it remains out of scope. If you need to engage in trust or company service work, automatically it draws the matter into scope, and you need to then ensure that you have all of the kind of the mechanisms of AML compliance in place. Make sure you've done a client and matter risk assessment. Make sure you've done completed client due diligence, and so on and so on. And particularly if your firm is only dealing in work that is out of scope, that can be particularly onerous because there's the wider structural pieces that need to be in place. Regulation 18 firm-wide risk assessment, Regulation 19 policies, controls, procedures, training, etc., etc. So it's one of these things to really kind of highlight the importance of that. Drifting into scope without realizing it is a rather big issue. So I've talked about kind of some of the differences, some of the similarities. I think I've said before that TCSP work generally is considered by kind of law enforcement, national risk assessments, etc., as being pretty high risk. And I think while there's a bit of diversity among TCSPs, I think broadly speaking there's some kind of really consistent issues there. So the main one is opacity. It's the value that trusts, companies, similar legal persons can provide to would-be money launderers in making it more difficult to see where money has come from. At a basic level, that is the kind of the TCSP risk in a money laundering context, and that doesn't really change when it goes from high volume TCSPs that are outside of the legal sector, or supposedly outside of the legal sector, to those that we supervise who might be providing it on a more ancillary basis. It still means that you still have the risk of adding opacity to transactions and just making it more difficult to understand where things are coming from. Moving on, as I kind of highlighted before, the key risk is not correctly identifying TCSP work. And I think this is something that's actually there in common with tax advisors as well. It's another area we supervise. And a lot of our emphasis is on correctly identifying instances in which you have drifted into scope. Because the key risk there is that if you don't have the customer due diligence, you don't have the client and matter risk assessments, yes, at a technical level, you are in breach, but also effectively you don't have the value of all of the extra information that you need to be able to judge what the risk is and to be able to kind of apply controls in a risk-based way. So it's not just a technical breach, oops, I haven't done the CDD. It's that you're offering trusted company services, which is nominally quite high risk to somebody you don't necessarily know who they are, or at least you don't know who they are with the kind of the necessary confidence that you should. So I think if there's one takeaway, it's to really look at that definition of TCSP work in the legislation. Again, it's Regulation 12.2, and really consider whether anything your firm does or anything your firm may do in the future is likely to drift into scope of that. Because if so, as I say, there's the kind of the technical issues of having to tell us and the different approach that we need to take as a supervisor. There's the fact that if you're not on HMRC's list of TCSPs, then you're operating illegally. But then there's also the kind of the risk management issue, that the tools of the money laundering regulations are broadly there to facilitate your risk management of your firm from a money laundering perspective. And if you're not recognizing that you're in scope correctly, you're not going to apply all of those various controls, exposing yourself to, frankly, just a huge and very scary amount of risk. So moving on, I keep saying the word risk, just to kind of dig into that a little bit more. One of the things that I guess in a way, talking about how ancillary and how potentially infrequent trust and company services are provided by firms we supervise, you might look at that in a way as a sort of mitigating factor in terms of impact. It's a more rare occurrence, therefore the volume of kind of opportunities for risk is a little bit lower. On the other side, a slightly kind of aggravating factor for TCSP risk is that one of the key things that's thrown out by law enforcement all the time is that TCSP work, the risk is heightened where it's offered alongside other services. So again, ancillary to other pieces. And the reason for that is that if you're a would-be money launderer trying to create a comprehensive, money laundering solution, let's say, to whatever the problem is, you might need to involve a trust and company service provider to kind of facilitate formation of trust and companies and so on. You might need to bring in other possible regulated professionals to facilitate other parts of that. And the idea is that the more services offered by the one individual or entity, the more you become a one-stop shop for a potential money laundering solution. So that's the idea as to why TCSP work, the risk goes up the more you're offering it alongside other services. And as I say, that's a pretty fair description, I think, for the most part, of how TCSP services are offered in the legal sector. So that's actually a kind of a more key risk, I think, is kind of understanding how the risk from TCSP work integrates with the other areas that you work in. So TCSP work with let's say employment law largely considered to be out of scope, so the risk there is kind of drifting into scope and not recognize it. It's kind of more that element. Whereas Conveyancing mixed with TCSP work is more sort of direct interaction between the two. That's kind of more what I was describing earlier, a more complete money laundering solution kind of issue. So the risks kind of change in that way. Another one that's highlighted in the literature is multiple addresses for virtual offices. I think that's a sort of a key issue. Again, it makes it very challenging for people to actually trace back through the paperwork as to where money is moving. I think I've already talked about the kind of inherent opacity of trusts and companies, and essentially they're just one layer, one extra layer, one extra requirement of work to kind of go back through the chain and see where the money is and who is doing what. But I think another inherent issue here is the limited ability to monitor, because by and large, TCSP matters, or the kind of that element of work, it has a smaller duration. And you might be involved, particularly kind of in trust and company formation at a very early stage, and then you may not necessarily have oversight of what is then done with that legal device. So it's just worth considering that your ability to kind of track how the risk develops could be more limited in TCSP work than in other forms of AML work. So it's just another thing to consider, and another thing I think probably in the if you're keeping score, it's probably another in one of the plus column for high risk in legal services. Moving on to what is my last slide before we kind of take a breather and talk about some of the questions that have come in. In the literature, and I'll go into a bit more detail as kind of what literature I'm referring to. There's quite a few red flags that I'm going to just pull out and just kind of explain a little bit here. So one of the ones that I came across was use of a pre-existing entity for a transaction. So this kind of falls into the bracket of there might be a good reason for this, but in the absence of a good and convincing reason, this might be a red flag. So particularly where it might be more obvious for a new trust or company to be formed for the matter at hand, and the client is saying, actually, this previous trust or company has been formed. It's just kind of on the shelf. We can just use it for that. Sometimes that is done in order to try to, disguise what the purpose of the transaction is. So it's been used for, let's say, totally legitimate conveyancing matter before, but now we're using it for something totally different, which isn't legitimate. But we're kind of borrowing the legitimacy of the previous transaction and kind of helping it carry it through to this. It's sort of a rather subtle method of money laundering, but one all the same. Jurisdiction. This is a really important one, I think, and it is one that requires a bit of further education. You're probably aware that there's a high risk third country list. It's quite narrow. And it triggers certain elements of the regulations in terms of enhanced due diligence, but that's not to say that that's an exhaustive list. It's really not. There's many other lists to consider when deciding what is high risk for your firm. And particularly if you're offering trust and company services, there's a lot of jurisdictions with very strong and well-founded reputations for increased opacity and lack of transparency when it comes to beneficial ownership, particularly when it kind of comes to trusts and corporate bodies. So understanding what those jurisdictions are and potentially a jurisdiction might be high risk for one thing but not for another thing, and just kind of understanding how that fits into your firm is something that is really important. And it kind of mixes with the next point as well. Multiple countries unconnected with the client. If the client's pushing you towards a certain jurisdiction and there's not a very clear reason as to why they're so keen on this jurisdiction, it's not a fundamental part of the matter, it cues up an automatic question for you as to why it's so important that this jurisdiction be used. And if the jurisdiction choice is because there is some lack of transparency, lack of information and beneficial ownership there, well then that's going to lead to further questions for you as to whether that's appropriate and whether that makes sense. Again, related entity type. So whether the entity type being chosen or being pushed for by the client carries greater secrecy. Historically, the one that was always kind of cited in the UK was Scottish limited partnerships. I recall they've made some kind of changes to that regime to address some of that, but then pretty much straight away there was movement towards Northern Irish limited partnerships. So this is a very kind of dynamic and I'll admit kind of hard to track issue. But again, it comes down to, is there a good reason, a good legitimate reason that the client wishes to do things in this way? And if not, it cues up the follow-up questions for you. Disguising the actual controlling party. Now, the example here to kind of think about is a family member who is divesting themselves of their, legal control of assets, but where you can perceive the possibility that they are going to retain functional control, and whether it be assets or a trust or a company or whatever. The point here is that there is an attempt to disguise who the actual controlling party is. Again, this is something, if you've become aware of it, you need to understand why that is. And I think probably more than some of the others, I can't really see there being a good legitimate reason for that. It should be considered very high risk, I think. Similar to the next one, bearer shares. I get a little shiver down my spine when I think about bearer shares and the risk they pose. I was thinking about them as kind of, well, they were in a way the original cryptocurrency. Actually, no, they're much more opaque than cryptocurrency, in fact. So I think, yeah, there's something to be very, very wary of. And if you're touching any matter that involves bearer shares, it should be considered extremely high risk, and really should be raising some questions as to why that's used at all. Finally, loans involving entities in the client's control are paid back before term. Um, I have paid back a loan before term in my life. Not all of them, but very occasionally, and it does happen for genuine reasons. But again, this is one of these ones where if it doesn't make sense, if it doesn't make if there's not a clear reason for this happening, it can provide a mechanism by which entities are kind of exchanging money without really business reasons being there, and effectively laundering money quite efficiently in that way. So that is a sort of a run through, I think, the key red flags. I'm going to take a pause there and see if we have any questions.
Thanks, Mark. That was really interesting. I appreciate it's quite a technical area, and we do have some questions that have come in. So just to start us off, is there a minimum amount or threshold of work for a trust or company matter entering scope of the AML regulations?
It's very easy to answer that one, and the answer is no. And TCSP work is not dissimilar to any other area of AML in that regard. There's really no de minimis when it comes to that. I did learn recently there is a de minimis for, I think, the financial sector in PACA for some elements of things, which is nice for them, but for the legal sector, no. There's unfortunately there's no exceptions like that. There is an element to consider in terms of your risk appetite, and if something is on the smaller scale, to kind of consider what does that impact the risk posed, and kind of taking that approach. But you would need to consider that in terms of kind of the wider context of who your client is, what the matter is, etc. Having £100 being transferred as a part of a matter versus £10 million. Yeah, there's probably a differential in risk there potentially. But as I say, you would need to kind of take the wider perspective as to how you approach that.
Yeah, and I suppose firms that are only doing a small amount of this work occasionally, they can decide if that makes business sense for them. We appreciate, there's a lot that goes into being AML compliant, and they could always review that and update their details with us, I'm sure. So apart from our guidance on TCSPs, is there any other useful content we've been asked that you'd recommend for people to review?
Yeah, definitely. The Legal Sector Affinity Group, which is a group of all of the legal sector supervisors, put together a revised package of guidance which came out earlier this year. The core of the guidance is actually forget the number of pages. It's very long. We're in the kind of 200 to 300 pages. But there is actually a subsection on TCSPs. Again, kind of unavoidably for TCSPs, it's a bit on the technical side, and I would say it should be read alongside our own TCSP guidance. But there's definitely some helpful content in there. The other thing I would, and I guess this is again for people who have the interest and have the scope to do so. The Financial Action Task Force, I haven't mentioned them yet in this presentation. Familiar to many, I'd imagine, but they are effectively the kind of the mothership of anti-money laundering. They're sort of a intergovernmental international organization who set the global standards. And if effectively, if you don't follow their standards, you go on their naughty step, and that's not a very good place to be, frankly. As I say, they kind of set the overall standards, but they also produce an awful lot of really detailed, in-depth guidance. And they have a whole guidance piece on trust and company service providers, which really kind of goes into much more detail than I've been able to go into in this session. So if you kind of want that that wider context, that is definitely one to read. Probably the last one I'll mention is the national risk assessment. It talks about trust and company service work in the context of legal services in one area of it. But I would also say, for the most part, the vast majority of the section on TCSPs is a very relevant read as well. Again, going into the detail of what the risk is in the UK, and kind of really highlights what the risks are that you're likely to encounter.
Thanks, Mark. And we've been asked if we are a law firm already regulated for money laundering purposes, and they've told us about this, that they provide TCSP work. Do we need to tell HMRC as well, which I think is picked up in the guidance? But if you could just cover that for us.
Yeah, the answer is no. The way it works is that you tell us that you are intending to do TCSP work, and then that triggers our process to consider the application, make our recommendation to HMRC, and pass your name to them. Generally speaking, their approval is pretty instantaneous. So kind of once it's with them, it's effectively on their list, on the register, and from that point forward, you can operate as a TCSP. But it just needs to kind of allow the time for that process to take place. But there's no need to be contacting HMRC for any of that. We have a sort of a streamlined arrangement with them where we kind of send over that information in bulk.
Great, thanks, Mark. We've had a couple more questions come through. Let me just have a look. I think this one might be more around sort of customer due diligence. I'm happy to jump in on this from sort of the work that my team does.
Sure.
So this question, if you are simply setting up a vehicle for the client and will not participate thereafter, how far should we go? So I think they're talking there in terms of what checks they should do. Would you like me to give some thoughts on that, or?
I mean, I just to say that, I mean, again, it kind of goes to the point of, that once you're in scope, you're in scope, and the full kind of the letter of the law applies. So all the stuff that's required in the regulations in Reg 28 and so on, and depending on the risk present, might be enhanced due diligence you might need to do. So just to flag that, and also just the kind of, I think that also kind of highlights that reduced ability to apply ongoing monitoring. It makes it more challenging to do that, and I think kind of is in some ways a little bit riskier, because you're kind of creating this trusted company and putting it out into the world, and how the client uses it, you can't always be sure. So, but please, Zoe, do add anything else.
Yeah, I think it's a good question, because it identifies those things coming into scope. That's not always about the money moving, which sometimes there can be that sort of misunderstanding that it's all about money. So I think it's a good situation to mention, because you could, if it is around sort of moving assets or creating the vehicle to do so, could find yourself committing an offence under the Proceeds of Crime Act in terms of facilitation, because of how wide that's drafted. So I think, as you say, Regulation 28, for me, the important thing is to understand why you're creating that vehicle, And if you're satisfied by the client's explanation, simply making a note of that on the file. If things don't add up, then that might trigger more checks. But I think that's a real simple starting point for that one.
For sure.
And I think finally, so conscious of time, we'll ask one more question. But if there's any other questions we haven't picked up or aren't quite in scope of the TCSP work, we'll try and answer those separately, or they can be answered by a professional ethics team. So last one, am I right in thinking that firms need to be registered and their beneficial owners, officers and managers approved before carrying out trust and company service provider work, Mark?
Yes, absolutely. I think it is the administration of this whole issue is a little bit challenging to understand all the finer details of, and I hope I was able to give a kind of a decent description of that. The guidance also kind of goes into that detail, but perhaps if there's one simple takeaway, it would be don't do any trust or company service work until you are approved to do trust or company service work. It's really important, because as we've said, if you're not approved, if you're not on the register, it is illegal. So it's really important in this context to recognize when your firm drifts into scope as a TCSP, which might be different to how you might drift into scope as an independent legal professional, to recognize that and to tell us via FA10 or FA10B on my SRA as soon as possible.
So thank you everyone for tuning in to the webinar. The recording of the event will be available on our events page and YouTube if you want to check this out later, and do consider our future events and booking on for those. We really do appreciate feedback on these events, on what we can do better, or other topics that might be of interest to you. So please do use the link and let us know how you found the session. And thanks again to you, Mark, for your time, and to everyone watching. And we'll try and pick up any other questions that have come in that we haven't been able to answer. So thanks again for joining us.
Thank you.